Hello and welcome back to Learn It from a Layman. I am Carl Christensen. I'm joined tonight by Matt, and for our longtime listeners, we have a returning guest, Mick McGirr, lawyer and basketball. No, actually, far better at golf than basketball. Um,
Not anymore.
No, Mick McGirr is our legal expert that came on, Mick, I think about 3 years ago that joined us and talked us through some licensing and things like that. Tonight, you're going to come back and kind of talk us through all variety of law. So thanks for coming back, Mick.
Happy to be here.
So quick bio for you, Mick. Once again, you graduated from Georgetown with your, is it JD, Juris Doctorate, right?
Yep.
And you passed the bar in Arizona, so your law office is in Arizona. It's Focus, Phocus, right? Focus
Yep.
Law. And how long you been doing that now?
Been in Arizona since 2011. Practiced since about then. Started Focus Law in it's been 5.5 years.
Awesome. So Mick has a lot of legal expertise for us, and I have none. So it's a good combination. We bring a lot to the table combined, is what I'm saying.
We have two laymen.
And Matt's going to chime in with any questions he has as well. But we're going to go here from the top. Mick, what are the different types of law?
Oh man, different types of law. There are many, many types of law. I think the easiest way to break it down would be, and this actually may be something that we talk about again a bit later, but there's civil and criminal. If we really look at the biggest buckets, criminal is there are laws that if you break them, you are criminally liable. Which really the easiest way to determine what that is that the state says you have some debt to pay to society as a result of your bad actions. And oftentimes, criminal, especially when you get to felony level, not misdemeanor level, it results in jail time and, the removal of certain of your rights as a result of your bad actions. Civil is really just anything where it's non-government actors for the most part. There are some places where government entities are part of a civil case as well, but really civil matters are between people or businesses. And within civil law, there are a whole bunch of different areas. You have business law, which is primarily what I practice, which is the law that governs and is utilized by businesses. You have estate planning, which is another area that my firm focuses on, which is kind of passing along, or the mechanism by which you can pass along your assets to future generations, and how to strategically minimize the amount of taxes that you pay. You're not allowed to use the word like tax avoidance.
Right. Yes.
And then there's family law, which is disputes over family matters, divorce, paternity matters, um, all kinds of things that fall under there. There's patent and IP law,
Okay.
Which is basically you create some sort of, this is really what we talked about in our initial conversation, was copyrights and trademarks and that sort of thing, which is
that's right.
When you create something of value, you should have a protected interest in that thing of value. Suppose I create a great recipe and I want to be able to be the one who, derives benefit from it. I can, patent that recipe. And patent law, IP.
Or the words, sorry, Taco Tuesday, which I recently learned are
Mr. James, yeah, terrible basketball player like myself. Anyhow, yeah, so you can secure your right or your ability to receive benefit from your ideas by patenting or trademarking or copywriting that. So those are kind of the big buckets of law that everybody thinks of. There's also things like environmental law, which relates to the environment of all things. There's anything. Well, here's the way I should put it. I could go on with this list all night because anything you can think of, there is a law related to it.
Right.
Entertainment, aviation, water rights, anything you look around and think, man, there's a thing. I look around my room and I see a rock. Yeah, there's geology law related to the mineral rights, all those things. So there are too many types of law to even describe, but those are some of the main high points.
And do lawyers specialize in each like little niche of law, or are just like a bucket?
So general practitioners are um, pliers of many trades, masters of none, and are generally pretty crappy at all, actually. Um, so it's if you're looking for a lawyer, you are best advised to go and find one who at least has a consistent presence in the area of law that you're looking at. Now that doesn't have to be hyper specific. My
Sure.
firm is kind of a general business practice firm, so our clients aren't heavily focused in any particular industry. Um, but across kind of all areas of business law, there are some commonalities. Whereas if you come to me and say, Mick, I'm getting divorced, help me, you're barking up the wrong tree.
Right, exactly. So you probably wouldn't go to like Matlock, for example, when trying to get some business law help.
It probably wouldn't be a good idea.
I turned to him for all of my law questions. Uh, didn't he die? But whatever.
Probably.
Okay, one question before we move on, though, because when you were talking about passing on assets, and it sparked a thought I'd had in the past that I'd always wanted to ask a lawyer: when you die and you have debt, does that pass on?
So, uh, in some instances it can, and in some instances it does not. Um, the easiest way to avoid debt attaching to your assets at your passing is going to be by having a trust in place. If you have a trust in place, you've basically assigned that the second that you pass away, your trust, a revocable living trust, becomes irrevocable, meaning that during your life, revocable, if you say, hey, I've transferred all my assets to a trust, but it's revocable, you can revoke that trust and they're still your assets. Whereas as soon as you pass, the trust agreement becomes irrevocable, meaning that the assets are then assigned to that trust. And so no creditors could come after you for debt or could come after your estate for debt as long as the assets are in the trust. The only exception to that is that if your debt is attached to property, like if you have a mortgage, that mortgage isn't personal debt per se. It's not secured just by your personal word, but it's also secured by certain pieces of property, like a deed of trust on a piece of land. And so debt that is tied to property, kind of in rem debt versus in personam debt. There's some terrible Latin for you. The worst things lawyers do. That's on the list. Anyhow, the debt that is attached to property will still be attached to that property after your passing. So it's not like you can have your mortgage wiped out and your kids get
Right.
your house free and clear just because you die. But if you pass without a trust, then all of your assets have to go through probate. And probate is an opportunity for creditors to say, hey, I have a right to some of those assets. So having a
Mm,
trust, if you have any meaningful amount of assets, frankly,
with
even
the
at the
trust.
couple $100,000 level, having a trust is beneficial because it makes sure those assets pass without creditors being able to attach themselves to it.
Huh, interesting. Okay. And that seems like it would straddle the line between like law work and also financial, like so right? A trust seems like
Yeah,
it's
there's
both.
as far as how trusts are structured, some of it's quite basic, but others of it, there other matters. Yeah, there's a lot of both tax considerations. In any estate plan, there are some tax considerations how to pass things without bumping up against gift tax or up against inheritance tax or death tax, however you want to consider that. So there are considerations like that. There are also considerations. We work with a lot of financial planners. That's a lot. That's where a lot of folks that get us engaged is through financial planners as
Right.
far as the estate planning thing goes, because financial planners have a good vision of how they want your assets to flow, and then they get with us and we put together the plan that makes that happen.
Okay, cool. Thank you. That was something personally might affect me in the not too distant future.
Hey,
Not
Carl,
that
let's
I'm
get
planning
you a
on dying.
trust, buddy.
I should have one. Okay, let's move back to the preset questions. Do law concepts transcend the type of lawyer? So we talked about the different buckets, the different varieties of law. You said there's something like there are general practitioners, but they kind of aren't good.
Yeah. I mean,
And
listen,
we
in a
just lost
small
all of our
town,
sponsorships from every general practitioner out there. Thank you.
I'm getting a bunch of hate right now, a bunch of downvotes if we're on Reddit or what have you.
All right.
No, listen, in small towns like where I grew up, you'll have general practitioners who handle family law, contract law, everything. And that's fine. But the types of matters they're dealing with typically aren't terribly complex. And so there's not a need for a lot of hyper specialization. But there are concepts that transcend the type of law or the lawyer that we're talking about. Um, the same the same principles of law apply, but if the question is, okay, do the same principles apply to a family law attorney as apply to a business attorney? They're just entirely different bodies of law, right? So yeah, some basic elementary ideas still apply, and the rules of civil procedure, which are the rules you have to deal with as far as practicing in court go. Yeah, they're often very similar, but um, no, that really the answer is kind of no to that question.
Okay.
Now, if the question is within business law, if I am a general contractor who builds houses, um, are there common principles of law as some of my other clients who are corporate finance and clients who are health tech startups? Yeah, there are very common themes that run through all those. The concepts of contract, bargain, exchange, liability, all those things are common themes. And so it makes it easy for somebody like me who practices kind of general business law to have clients in a variety of industries and with varied concerns, because the laws are all fairly common. And so if you can figure out the issue in one area, you're going to be able to figure out another as well.
Okay, that makes sense. That's why, so you can essentially specialize in a bucket, and the across the bucket there are concepts that transcend this specific niche.
Yeah,
Right.
that's
Okay.
correct. Yeah. So family law practitioners, there are common themes from divorce to, child rights and everything else.
Right.
But it's kind of hard to take a family law practitioner and put them into patent law without them being quite confused.
Right. You don't patent your children, Mick? Come on.
I pat them hard when they do naughty things.
Nice. Okay. A couple definitions then for me, and these are probably like basic entry level things that you do at law school, but I never went to law school. Though I
And
should
you're
have.
a better man for it, Carl.
Mick and I did live together actually at the time that Mick was preparing to go to law school, so some of this should have rubbed off, but it did not.
It didn't.
It did not. Not a piece of it. So, what is jurisprudence?
Jurisprudence is just the study of laws and statutes. It's jurisprudence is really so. If I, it sound terrible. I have to think my degree is a doctorate in jurisprudence, so it's just the study of law.
Okay.
It's
Nice.
general.
And okay. What is statutory law?
So this is a cool question that actually has two answers. The main bodies of law are statutes and case law. So um, legislature, we vote for our representatives both at the state and federal levels, and they draft legislation, and that legislation is laws once it's approved. And those laws are statutory law. Basically, they make rules and they put them in writing, and those laws become codified, and we have to abide by those rules. So one area that you can find law is through the laws, through the statutory written laws. The other area where law develops is through case law. So there's every time that a judge makes a decision at the appellate level, not just your local court level, that's not really binding on anybody except for the case that's being heard. But at the appellate level, whenever a judge makes a ruling, that ruling kind of sets a precedent for all the matters in courts below it and within that court. So say you have an appeals court that within the state level, the highest appeals court is the Supreme Court of that particular state. So gets appealed to the highest level of that state. They say, you know what, the rule is that, guys named Jim can't hit guys named Sam. And that's the rule. Now, all the courts below it, somebody named Jim comes and says, or Sam comes and says, hey, Jim hit me. They can look at it and they say, okay, well, while there isn't a law that's written out in statute, there is a law because a court above us said that this is how they ruled on it. And so now guys named Jim can't hit guys named Sam. So you can look first to the statutes and then also to precedent case law.
So that sounds like, okay, so statutory law seems like it would be very easy to put in a single place, like index it and be like, oh, these are the written laws. Case law sounds insane to me.
Super messy.
Right? There are a lot of judges.
So the nice thing is that for state law issues, you only look upstream from where you're at. So the binding authority on a matter in Maricopa County, Arizona, is going to be within the appeals courts in Arizona and the Supreme Court of Arizona. So you're really just looking upstream from there. If you're in a federal matter, you look upstream. So say you have a federal matter in California, you look first at the appeals courts within California, the federal district courts, then you look above that to the Ninth Circuit, and then you look to the Supreme Court. So that helps because you really are just kind of looking at this pyramid of precedent, right? You're going upstream.
Got it.
But you are correct. It gets really tricky. And that's one of the things you get taught in law school is figuring out what precedent is binding on your particular circumstances. And the job of a lawyer as far as drafting their pleadings and as far as arguing cases is making a convincing argument that the bad precedents that aren't favorable to their client are somehow excluded. And so you're looking at these precedents that say, oh, guys that spell Jim G-Y-M rather than J-I-M actually can hit other guys. So you're going to say, well, listen, the initial precedent was about a guy named J-I-M. My guy's name is G-Y-M. So my guy isn't actually subject to that rule. And look, here's another rule that says that guys who have names of sporting facilities can, in fact, hit guys named Sam. So you're basically taking all the rules and laws that are there and explaining why they should or should not apply to your particular instance.
Okay. I'm assuming this example is definitely based on actual, literal, real world occurrence.
I've got a sick mind, Matt.
It sounds too well thought out to have just been something on the fly here.
Terribly thought out. It's on the fly.
Very nice. Okay. Yes. No hitting of Sam. Okay. What is an attorney versus a lawyer? Are those the same?
So they're actually not. Listen, everybody uses them interchangeably, and that's fine. No lawyer or attorney is ever going to be offended by being called one or the other. We're a group who doesn't easily take offense because everybody hates us, so we don't have the right to be offended.
All the lawyer jokes, you mean?
Oh man, they're endless. What do you call 15 lawyers at the bottom of the ocean?
What?
A good start.
A good start. All right.
But so a lawyer is somebody who has completed the study of law. So once you've graduated from law school, you are considered a lawyer. An attorney is somebody who has passed the legal profession entrance exam, being the state bar examination or federal bar, or whichever bar you happen to be before, somebody who's licensed to actually practice law. So lawyer is a guy who has studied the law. Attorney is, in most instances, a lawyer who then also has passed the certification requirements to be licensed to practice.
Okay.
And then Esquire, which is the little ESQ that you put after the name, denounces that you are in fact a licensed attorney. So there are a lot of situations where you'll see somebody write their name and then comma JD afterwards, or even call themselves a lawyer. That's fine, but it typically will mean that they're not licensed to practice in whatever jurisdiction you're dealing with.
Hmm. Interesting. Okay. Well, so what you just said led me right to the next question that I've always wondered about. So the bar, not talking about like a place where you go get a drink, but the bar, as in, yeah, when you
As in, what is it?
I have no idea. Like, is it a like it's not a certificate, because then you talk about getting disbarred, whatever that means. And then like it almost sounds like it's a group of, men and women that sit around like scheming on how to make new laws. What is the bar?
So bar does not make laws. The bar is the sanctioning or regulating body for attorneys. So there's the state bar of the state of Arizona. Each state has its own bar association, or bar, and it is basically the regulating body for those attorneys in that state. So it actually began within courtrooms conventionally. This is from what I've read. It could be a lie, but it wasn't on Facebook, so I think it might be more true than not.
Okay.
But
All
there,
right.
there actually is still, if you go into a courtroom, there's the seating section for the crowd, the spectators, and then there is a divide, a small half wall, usually with some double door opening that you go through, and that's considered the bar, and you can't cross that threshold unless you're an attorney or unless you're being representing yourself in a case. And so conventionally that was kind of considered the bar. It was exclusive. If you were in front of that, you were trying a matter before the court. So that's where the term came from initially, was crossing the bar, and then it just kind of evolved into
What it is
this
now.
intimidating term that everybody says. Now
Right.
amongst attorneys, it's like, oh man, I got a call from the state bar, and it means that you're in trouble, or that you've had a complaint filed against you. So it's the governing body for attorneys, and there are bars at the state level. There's federal bar, but yeah, that's what it is.
So you said there's ones at the state and the federal level. Do you have, so when part of the process of becoming a lawyer, like a licensed lawyer, is passing the bar exam, right?
Correct.
Is that only for a state? When you pass it, you also, is there a separate one for a federal?
So not
bar?
a separate test for the federal necessarily, but you do have to apply to be licensed before you have to apply to be allowed to appear before federal courts. And so when you ask, in what jurisdictions are you barred? You'll say the state jurisdictions. You'll say Arizona, California, Washington, and then you'll also talk about what federal jurisdictions you're licensed to practice in. Federal district in Arizona, the appellate courts of Arizona, and that sort of thing. So that's the bar, or where you're barred, means which jurisdictions you're able to practice in.
Okay. And I would imagine then, so when you take the bar exam, that's why you are licensed in Arizona. The laws in the state of Arizona are different enough that if you came to California, that's why you would also need to pass a bar exam in California, or?
So, yes, to some extent. The biggest differences in laws are really the rules of civil procedure and the rules of practice before the courts of those different states. So I have clients throughout the United States that are businesses, and I'm able to offer legal advice and draft and review documents for them, kind of in most jurisdictions. But where I need to get somebody involved who's licensed in that state is typically when matters go before the court. That's where you really need to have licensure in that state or in that jurisdiction.
Okay.
So I have clients. We just finished a transaction where my clients were a business based in Oregon. They are being acquired by a fund based out of Chicago, and all the new entities were going to be in Delaware, and jurisdiction for the whole transaction was Delaware and New York. So you can imagine there's a whole bunch going on there, but we all kind of, know there's commonality amongst most of the laws, and transactions are very similar wherever you happen to be. And so, yeah, you go for it. And if you need certain issues resolved, you can find somebody in that state who specializes in that, but doesn't happen that often.
Yeah, that's what I was, because you do, your law firm does business law, right? That's but businesses aren't. I mean, of course, there are mom and pop shops around that are just in a particular state, but a lot of, businesses, obviously larger businesses that would want your services, are going to be multi-state, even international. And so in that case, you have to either have a large network of lawyers, or I mean, how does that work?
So it's a bit of both. Like I said, to some extent, you don't need licensure in each of those states where you might do, a modern amount of business. But I do have attorneys in most states where I most commonly have clients. And so in the instance that I have somebody who is in New York, I've got a firm that I use in New York who's local counsel for me and who can kind of vet major issues of concern that need a more local take on them.
Okay.
And then you
Cool.
talked about international, and international law is a whole different bag of tricks. There are international law firms, and really it's a bit convoluted, figuring out which jurisdiction actually applies, what law applies, all those things. It's not much fun. And that's why most international law is handled by really massive firms that have locations in each of those countries. I have done a bit, I have a client that's a bank in Peru that does lending here in the United States. And so, we do some interjurisdictional work like that. I have some clients that, have offshore banking for tax minimization.
Optimization. Yes.
So we do some things like that, but complex major international matters are best handled by firms that have many attorneys in each of the jurisdictions.
Right.
And so they all end up in a boardroom together, charging the one client for the 10 attorneys who are in the room at, $1,500 an hour per attorney. The bills get really, really big. And so if you have a complex international issue, you better be ready to have a complex international bank account.
Makes sense. Okay. You're on a podcast called Learn It from a Layman. Not a lot of complex international businesses. So in that vein, like, what you've already told us about, like a trust, right? That's something that I think the layman probably should know about.
Yeah.
Are there other like little tips that you have, as far as like, this is what the layman needs to know about setting up their legal matters?
Sure. The primary things that I would say, first is, if you are starting a business, especially if you're going to have partners of any sort, if it's not just you going to business, you should consult with an attorney and have an operating agreement drafted. This could be as simple as you're starting, lemonade stand that is a little bigger than what your kids would have, and you have a couple partners and you're each putting in $1,000. Immediately you should address, an operating agreement is going to determine what's everybody's right, what are everybody's rights, and also what are the obligations when you break up. You should go into every business relationship assuming there's going to be a breakup at some point, some sort of divorce. And so by planning at the outset what the mechanism is for getting everybody out of it in a happy manner, you're going to preserve relationships, and you're going to save a ton of money in legal fees fighting over who gets what in that scenario. Second thing I would say is, lawyers, some of the stereotypes are accurate. And so find a lawyer that you trust, that's a genuine human being, and try to make sure that there's somebody who's not just going to look for how to bill the most hours in any given situation, rather
Yes.
somebody who's going to look at it and say, this is the wisest outcome for you. I try to talk to my clients about the fact that it's my job to give them what the legal outcome of any situation would be, but then also to talk to them about what the wise business decision is. Because just because I think we can litigate a matter and go to trial and win doesn't mean I think that we should. And there are going to be a lot of attorneys who you come to them and say, hey, Mick, I've got this issue. Um, what do you think? Is it a winner? And less than ethical attorneys going to say, yep, it's a winner. Let's file suit and let's go. And they're going to bankrupt you in legal fees. Whereas I would say, frankly, probably half of the folks who come to me with litigation matters and say, Mick, I want to file a suit. I want to go down this avenue. I say, you know what? I think that we shouldn't be looking at trying to get a judgment in your favor that might be worth the paper that it's written on if you can't collect on it or enforce it. And instead, we should be looking at how do we make this problem resolve in a way that might not get you quite the stroke of ego that you are looking for, but that does in fact resolve the problem and does so in a way that's not going to cause you to end up in the poorhouse.
Right. Yeah.
So
well,
that's a really big piece of advice boiled down to make sure that your attorney is giving you sound, not just legal, but also insightful, holistic advice.
it's interesting because it's almost like you need to get to know the lawyer outside of the law profession to know whether or not they're like a stand-up human being. Because I mean, if I knew you as a lawyer, well, I do now, but I don't know how I would be able to tell the difference between a Mick and a someone that is going to just pull the wool over my eyes.
Saul Goodman.
Yeah.
There are different, I don't know, Mick, maybe you can speak to some of the ones that are most trustworthy, seeing as how you're definitely trustworthy yourself. But there are a number of like review sites available that people can take advantage of. I mean, everything from Google to Yelp to actual law-focused review sites. Any thoughts on if any of those would be useful?
Yeah. So much like the Better Business Bureau, they're of mixed value. One of the issues that you run into with all of them, and I'm on the other side of this equation from you guys, is I know how those sites work. Now, if you go on to, I'm trying to think of what the Avvo is, one of the big ones, Avvo, AVVO. You can go on there, you can see how is this lawyer rated? And I think that my rating on it is like a 9.5 or something like that. I have a very high rating. Now, that's unique because they reach out to you. I get probably 15 calls a week from different agencies, different groups, different websites that all rank attorneys and do all these things. And they're all like, well, you should get your profile set up with us. One of the upsides is you'll have a 10.0 rating. So just like Better Business Bureau, if you pay your dues, you get a good rating. And there's also attorneys who actually do work hard and who have clean records and who do that and who have good ratings because of that. But it's hard to really be able to rely on those resources because just by paying and keeping your nose relatively clean, you can avoid, not having a pristine rating. So I think that the way to go about it is the way to discern who you can rely upon and who you shouldn't is, this is maybe self-serving, but I really encourage, if you are within a certain industry or you foresee certain issues in the future, listen, if you're going to an estate planning attorney, most of them aren't going to rip you off. The pricing is what it is. You're going to be between $2,000 and $4,000 to have your estate planning prepared. That's fine. But when you're talking about litigation or you're talking about business, if you can establish a relationship with an attorney before a problem becomes significant, you're going to have a good idea of how they're going to handle that problem when it comes to a head. I was talking about kind of preventative maintenance. If you are starting a business, have a relationship with an attorney, no matter how small the business is and no matter how small the relationship with the attorney is, because they're going to be able to provide you some insight. And if you have an attorney who only wants to bill you and isn't providing value, you're going to suss that out pretty quickly. So my recommendation on that is do what most people can't imagine doing and develop a relationship with, the scum of society, your local bar.
Very nice. Very nice. Play the long game is what you're saying.
Yeah.
Hold your nose and befriend the lawyer.
That's exactly right.
Very nice. Okay, a couple more things to hit on. Oh, by the way, when you were talking about getting some agreement in before, as you start a business, it's a good thing this podcast is not a business, because Tim is a diva. I mean, he already demands like his like dressing room. I think it's dressed.
Well, Tim called me before this session and was telling me how he's already in makeup.
And Mick, I'd like to talk to you afterwards about what legal action I can take against these guys, because I really feel like I have some grievances. You're getting ripped off. I'm worth so much to this group. You have no idea.
I'm here for you, buddy.
All right.
Very nice.
It's a good thing I already have an established relationship with you.
I've been waiting to get my pound of flesh from Carl, so we're good.
Yeah. I'm your in.
That's right.
Yeah, yeah. I think Mick would probably have a few things he could hold over my head, but vice versa, Mick. So you can play that game. All right. Okay, so class action suits. That's something that the layman is familiar with. I actually got one in the mail recently about, like, if you want to get a piece of this action, like, what is a class action suit? How do they start? And how come I get involved if I don't feel like I ever had anything to do with them?
So a class action lawsuit, most lawsuits are going to have a single plaintiff, single aggressor, the person filing the lawsuit seeking damages against the defendants. You have plaintiff, which is the one who files the suit, and defendant, the one who is defending the lawsuit. Typically, you're going to have a single plaintiff and either a single or numerous defendants. A class action lawsuit is where there are numerous people with a very similar type of injury or damage. And so in order to kind of efficientize the process and to be able to pool resources, you can file, rather than as an individual, you can file as a class of plaintiffs. So you have a class action. Class of plaintiffs being more than one plaintiff, so more than one person on the top part of that equation, pursuing damages of a similar type against a common defendant or defendants. In order to certify as a class, you have to be able to establish that that the fact pattern for each of those types of damages are similar. If you think back to, I'm trying to think of what the movie was, an old John Grisham book turned into a movie. I think it was maybe the Rain Man or not Rain Man. I like that movie too. Rain Man reminds me of Carl.
Rainmaker. I think it's Rainmaker.
Just kidding. Kind of. No. I need to take Carl to Vegas is what I need to do. Class action. The movie, the John Grisham book, they're going around trying to get a lawsuit against a tobacco company. And so you can imagine all the people suffering from, damage from tobacco, from smoking tobacco, from improper warnings, and all those things. They would have a very common type of damage as a result of them all having been victims of the same scenario. They all smoked. They didn't know the smoke was going to cause damage. There wasn't proper warning given. They were subject to predatory marketing. And so they can all say, we should all be in the same group going against Marlboro, right? And so when that happens, then there's a class representative or kind of the lead plaintiff. And that lead plaintiff is really the one who ends up hiring the attorney to represent the class. They're the ones who most directly consult with the attorney, but they're representing a group of people. And ultimately, if there's a settlement, they're also the ones who approve or deny the settlement offer. So in exchange for being that lead representative, oftentimes they get a larger portion of the damages that are awarded at court, or also the larger portion of the damages that are awarded in settlement. So you can imagine if there's 1,500 smokers all who want to file suit against Marlboro, and there's a lead representative, Mick, who is a longtime smoker, has a mechanical lung. I would say, okay, well, I'm going to be the class representative. You get everybody to sign off from the class that you're going to do that. You go through the litigation process. Oftentimes, that lead representative is one who works most closely with the lawyer, who takes the stand. And the lawyer is going to try to put on a case that represents the whole class, probably using some anecdotal evidence from a few of the different people. And then the judge oftentimes will say, okay, well, we're going to award damages, or however the damages are awarded, whether it's through jury or judge. They're going to say the damages are in the amount of $15 million. There's, let's say 1,000 representatives. So everyone's going to get $15,000 in the class, or 15,000. My math isn't there. That's why I bring Carl along. But and then they're going to say, but the class representative, that lead plaintiff, is going to get 3 times the normal share. So that's what a class action lawsuit is, kind of the mechanism of it. And you don't have to join a class. When you get an email, Carl, saying join a class against Facebook for the
Right.
divulging private information, all those things. The reason they're submitting that is they're trying to increase the size of the class pool so they can get a larger award, make it look like there are more victims, more interested parties. And there's also some obligation to notify people who might, if they can identify what that class looks like, there's also an obligation to let them know, hey, we're litigating a case that you might, intend to litigate yourself. And so you should get in on this if you want to. You're not required to, but it's a little harder to win that lawsuit on your own rather than as part of the class.
Interesting. Okay. Now, and you said that there'll be like a lead plaintiff who interfaces with the lawyer more. Is that plaintiff also the one paying the lawyer's bills?
So they are, but oftentimes the class is set up in such a way that the fees are collected and then remitted through that lead plaintiff to the attorney. So, one of the nice things is you're trying to pool resources amongst common victims or common plaintiffs. And so you can say, okay, if it's not a contingency matter, there's 2 different ways the lawyer is really getting paid on lawsuits. It's either, by their hourly rate, which, is they just get paid as you go along. You submit a monthly invoice and they get paid on it. Or there's contingency, which is if I win, then I get a portion of the winnings. And so, in a $50 million case, you get 30% of it. The lawyer's looking at a nice payday. In that instance, having a class is a lot easier to do because the class probably isn't going to go bankrupt paying those legal fees. But if you have a weak case that, no lawyer wants to take on contingency and they're taking on an hourly rate, then yeah, the class representative would be one paying the bills, but generally they're collecting fees from the other plaintiffs, from the rest of the class, and paying them in that way.
Okay. How often are do lawyers work on contingencies? Like, seems like that would be a dicey way to kind of run a business. Is if I win, I'll get money versus this is my rate and I'll do my best.
The frequency with which attorneys get paid on contingency is the frequency with which cases are good. That's really what it comes down to. No lawyer is going to take on contingency a case they don't think they can win. And it's really just kind of a factoring / gambling scenario where, I worked for a firm early on in my career that did debt collection. They did judgment. They pursued commercial business defendants who owed money to, major construction supply companies and whatnot. And it was just a numbers game for them. If they had, 3,000 matters, all that went to judgment, sure, they weren't getting paid until, they collected, but on 3,000 matters, they're going to get paid on 1,500 of them. And that was worthwhile because it was kind of I don't want to use the term sweatshop, but there's a lot of volume that went through. And so it's a numbers game. Taking contingency matters, if you have very few cases, is probably not a sound business model.
Right. It has to also be kind of dependent on maybe even the type of law. Like if I'm out there ambulance chasing, if I'm in an accident, like the people that I'm representing aren't going to be able to pay me, my normal legal fees. So I have to get them from, whatever, right?
Personal injury attorneys are, most of them operate on a contingency basis. And you'd be shocked when you go into some of the bigger personal injury firms. They'll take almost any case because they're going to send an initial demand letter to insurance. And if the case is weak, they're just going to say, okay, you need to accept the terms that were, offered by insurance, no matter how bad they are, because they're not going to invest time in a matter that doesn't, pay much. But if they have 3 big cases that are going to get them, a contingency fee of $1 million a piece, and then they have 500 small cases that are going to pay $1,000 a piece, at the end of the day, that $1,000 a piece on the small cases is still revenue for them. And so they are going to kind of do a lot of churn and burn on those type of claims.
Okay. Makes sense. Okay. Let's see. You've had a few of these as we've moved along, but so judges. It's unclear to me, because most things are unclear to me, what path you go from a lawyer to a judge, or is that always the way it goes? Are judges, is that like a track in law school? How does that work?
Yeah. So, man, I'm trying to remember what they told us in law school. I think it was A's become academics, B's become judges, and C's become practitioners who make all the money. That's really kind of how it goes. If you, and maybe I have the top 2 reversed, but I don't think I do. A lot of times judges are, in most instances, it's required for most types of judge positions. It is required that you do, in fact, have a law degree. And in most instances, I believe you're required to be barred, but I don't know if that's actually a requirement for all judges. So most judges are. Now, I will say that some lower courts, like Arizona, has small claims, which is, any Joe Schmo can be an officer of small claims court. But then you have justice court, which is claims under $10,000. Attorneys can still practice there. They're an elected position. You have justice of the peace is a position, and they are a judge. You have jury trials and everything at the justice court level. And most JPs, most justices of the peace in Arizona, are not educated, legally educated, or licensed. I think there's maybe one in Maricopa County out of probably 20 JPs that are in fact, that one is in fact a licensed attorney. So in some instances, you'll have judges who are not attorneys, but at the superior court and up level, most are either attorneys who practiced and ended up, deciding to go down that path, or they're, folks who took a different path and maybe they were law clerks for some time and then ran for office to become a judge. I have a friend who, 5 years ago, so when we were 5 years into practice, decided to run for Superior Court judge in Milwaukee and ended up getting elected. And, that's her career path now. So.
Nick, can I ask, why are so many justices of the peace not educated in law? And is that bad, or how bad is that? Or is it not a big deal?
As an attorney, it can be frustrating. A lot of them are, very diligent about their jobs. They try to get up to speed. But I'll be honest, the education that's offered to a newly elected JP is very limited. And so a lot of the burden is on that justice of the peace to educate themselves. And you end up in some jurisdictions where the JP doesn't know the law. I actually was at a trial, one of the very few civil jury trials at justice court level. My client's an air conditioning contractor, owns a nice regional business, and my client's business was sued by an unhappy customer. My client had done all that they could, and that unhappy customer obtained some discount or free legal services. I'm not sure what the scenario exactly was, but the attorney also was clearly inexperienced. and demanded a jury trial at the justice court level. And it was that the process ended up being me having to educate the justice of the peace on how a jury trial needed to be run. There were so many things where the JP, the opposing counsel would say, "Oh, this needs to happen," and I had to go back into the rules of civil procedure for the justice courts and say, "No, that's actually not. That evidence needs to be excluded, and the jury can't be here while we're talking about the exclusion of that evidence because it violates, the." So it can be a real disadvantage in some instances, Tim, to have a judge who does not understand the practice of law well or does not understand litigation well. But the reason for it, I think, is they're trying to keep those justice courts a little more informal and a little more litigant friendly, and so they kind of feel like, well, let's just allow a normal person to be in there doing it. Unfortunately, now there are so many cases at the justice court level that the informality there's a very complex set of rules and everything else. So it's a give and take.
Nice.
Do you think it's a problem that judges are elected?
I don't know that I'm allowed to speak on this issue.
Yeah, no kidding.
It's an interesting thing. It really is. Elected judges, there's the potential for some real conflicts there. I know a lot of judges who are outstanding people and who have impeccable ethics, and I know others who maybe aren't so squeaky clean, and you end up feeling like, man, there's a vested interest in what's going to happen here. But there are so many judges. You got to remember, at the Superior Court level in Arizona, I think there's probably, there might be 200 judges. And so if you think about how many judges that is, and the ability to actually appoint all those judges and the differing intervals of time that they serve, I think that it becomes impracticable to have that many judges appointed. And so I think that while it's not real tidy to have them elected, it's kind of where we end up at.
Yeah, that's interesting. I know personally, when the judges are on the ballot, I never know anything about them.
You have no idea.
Yeah,
Absolutely none. Yeah.
So the only way that you get elected is someone just filling out random ballots or you have some type of network that's doing something for you, right? Like
it's pretty painful, man. Even Samantha and I, in the most recent election, we went down the list of judges and we just didn't fill in most of them. I filled in the ones that I knew were either good or bad. And beyond that, I mean, I think I can't remember the exact number. There's probably 30 plus judges on the most recent ballot. And I knew 5 or 6 of them, and 4 were good, 2 were bad. And that was all that we checked, because who knows? And so maybe that's part of the good of it, is that you end up with this random smattering of judges who may be great and maybe not. And hopefully, we didn't accidentally bubble the wrong one. So
right.
I think that's a good description of the outcomes of democracy more often than not. A random smattering.
Sometimes I wish it was a bit more random than it is.
Very mixed outcome. Okay. How often do you work with a judge, Mick? Like in your day-to-day, legal work? Is most of it outside of the actual court process, or what? Yeah.
So this really depends on the type of law that you're practicing. One of the attorneys that works with me, his name is Sam. Sam has had a very litigation-heavy practice recently, and so he was dealing with judges. I mean, the best example I can think of, actually, a good friend of mine, Aaron Coleman. He has a landlord. He represents landlords in eviction actions. He deals with judges, probably 5 or 6 cases every day. I mean, I'm not kidding. He and I have been on the golf course, and he's doing a trial because that's that's the volume with which he's dealing with judges. So depending on the practice. Now, transactional practice, like mine has become more recently, the last several years, you deal with no judges because everything is done between the parties to a transaction. It's a lot of negotiation, a lot of contract back and forth. But for me personally, I have a few cases that I'm litigating, and I probably deal with a judge in differing manners once every couple weeks.
Okay. So, but obviously, in like you said, for different lawyers, it would be very frequent.
Family law practitioners deal with judges a ton. Criminal practitioners almost constantly because they're that's the
doing.
main
Right.
arbiter of every claim they have.
Right. Interesting. Okay. Couple more to round us off here. Lawyers, are there limitations set on lawyers or I'd assume judges as well about like serving in a jury?
I got called for jury duty first time ever about 6 months ago, and I just didn't respond. Samantha teed up for me. It was in the middle of a big transaction. I had a $120 million acquisition going on, and she said, "Oh, hey, this came in the mail. You should probably respond to it." And I put it on my home desk, and
nothing
it was
got
like
done.
4 months later, I saw it again. I was like, "Well, I guess that didn't happen." So no, there is no rule against attorneys or judges, for that matter, being on a jury. But when you're going through voir dire, which is the process of selecting a jury at a trial, a lot of times they're going to say, "Does anybody here practice law?" And
You're
the
out.
reason for this, yeah, I'm like, yeah, dismiss me right now. The reason
Right.
for it is they don't want somebody to come into it and frankly, they want it to be a jury of your peers, right? And your peers aren't knucklehead lawyers. So
yeah, right. Okay, but I had thought that it would be so clear cut that you don't want a lawyer on, like, at least the attorney, the actual lawyers on the case wouldn't want lawyers on the jury, that maybe there was just a law about it. Like, let's not waste everyone's time by bringing a lawyer in only to get kicked out in this jury. Times. What was that, Tim?
Oh, I was responding. Oh boy.
Yeah. Looking forward to it.
Carl, learn it from a layman. Joins the jury. You could do like a documentary style, like, okay, I'm here in the jury chamber.
Pretty sure
I can say that is a documentary that would not be watched.
Yeah, that's right. It's so gripping.
Yes, very low quality dialogue. Okay. What does on retainer mean? Like, I've heard this talked about before, and I have no idea what it means.
So for certain of my clients, typically higher needs, bigger businesses, they pay me a monthly fee just so they can call me whenever they want. And it's a retainer, or so they can have some of my staff available for their legal needs whenever they need it. And it's something that you just work out. You figure out what their needs are going to be. And, if you have a client that uses you 30 hours per month and your fee's $330 an hour, if that's the average, after some time you can say, okay, let's just do a flat $10,000 retainer per month, and you can use us for as much as you need to. And that's what it is. The other place where a retainer comes in is actually a deposit into your trust account, and a client will give me, I say, okay, listen, we're going to handle this transaction for you. It's probably going to cost $40,000 in legal fees. I'll take a retainer up front of $10,000. I'll bill against that at my hourly rate. And then when that's exhausted, they'll have you refill that retainer. So being on retainer typically means you're paying kind of a flat fee to your attorney to have them available to whatever extent you kind of have agreed to in that retainer agreement. And the other version of it is that you just pay them so they have money on their account. So you are more or less entitled to have their time.
Okay. So does that mean I need to have you on retainer? Like, or am I being billed hourly for this?
No, this is hourly.
I was hoping it was contingency.
The massive winnings that are going to come from this podcast.
We're planning on settling out of court.
I want equity is what I want, you guys.
All right. Yeah. A percentage, going to take a cut. All right. Good luck. I think so far this podcast has made almost, a $50 bill, Nick, over the course.
Hey, that is one small dinner for us together.
Okay. Last question. Well, it's a double-barreled though. So you work with businesses. And you said that going into a business, you should have a legal agreement set up. So you're essentially saying all businesses essentially should have some type of legal services available to them and make use of those. Is that true? And if so, how do you you're going to create a small business, you're usually cash strapped. What's your advice for how to get good legal services while maintaining a budget?
There are firms like mine that are aware of the financial restrictions and limitations of small startup businesses. And now listen, if your startup business is a lawn mowing business where you don't ever intend to expand beyond one mower and one truck and that sort of thing, well, first of all, there's not going to be a requirement of a lot of legal services. And so realistically, you can probably have your LLC set up, your operating agreement done, all of that. It's going to be quite simple. Maybe it costs you, $700 when it's all said and done. That's a one-time expense. You've established the business relationship with the attorney in case you ever do get sued, or in case you ever have, maybe somebody comes along and says, hey, I want to buy your lawn mowing route. And, I think it's worth $100,000 now because you do all these lawns and you get evaluation, you got that process. And so at least then you have the relationship there in place. But in other instances, I have one of my great clients is a health tech startup company. They went through a few rounds of fundraising, some seed capital. And at the outset, the understanding is they're going to be a bit cash strapped. And so we do a few different things where you can set it up where there can be deferred payment. Also, it's just kind of a matter of understanding that we're going to grow with the needs of the company. I've got a couple instances where payment has been made and kind of phantom equity in the business where, okay, upon a major cash realization, whether it's an additional round of funding or whatever, I'll get paid as an equity owner in the business, that sort of thing. But a lot of these businesses, it's the long game, Carl. It really is. It's something where I realized that, listen, as there's three guys huddled in one office trying to get this business off the ground. It may not be a $30,000 or $40,000 a month engagement for me, but that depending upon the quality of the business plan, all those things, there's an interest for me in maybe being more affordable now, knowing that the growth of the business is going to necessitate and enable them to pay for much more extensive services in the future.
Makes sense. So once again, that's the flip of what we talked about before, as far as people investing in long-term relationships with lawyers, so that you make sure you get a good one. This is lawyers investing long-term relationships with people that they think eventually will turn a profit and be able to give them good work. So
I have a lot of folks who come to me and say, okay, what's the price on this and this and this? And I tell them, and they're like, oh, that actually seems pretty low. And kind of what I tell most of my clients at the outset of our relationship is, I don't expect to be able to retire off you in this one transaction. I would rather treat you well and have you feel like you can trust the relationship, that you're not getting an invoice for bill or for fees or services that you don't even understand what it is or why they cost as much as they did. I'd rather that we have a good relationship. And guess what? If I have a few hundred clients like you for the next 15 years, then I can probably retire based on that. But I don't want to, I'm not selling my soul for one transaction to get me paid quick and move on, because my name is worth something. My firm's name is worth something. And so those extended relationships are really where the value is for me.
Nice. Well, that seems like a good place to leave it. So once again, Focus Law, right?
Yeah, if you want
Website?
to, website is focus, PHOCUS law.biz, B-I-Z. You can always reach me at Mick, M-I-C-K, at focuscompanies.com. And we actually are on Instagram and Twitter, or no, not Twitter, Instagram and Facebook. If you just search for Focus Law, you'll see us on there. Especially on the social media, self-interested, but I think they're worthwhile follows because we do put out some content that is informational and valuable to, we try to make it as layman friendly as possible. And I think that, we explain some concepts that are important, and we do it in a way that hopefully you can understand it fairly well.
And an aside, but though I think you also do this for part of your company, right? For your firm, you are a avid classic car guy, and I think you do a car show, don't you, for part of your firm?
Yeah, we do a charity car show. We do it each year, kind of in the first quarter, generally in January, February, maybe March. And yeah, we've got, this last year we had a great turnout. We had some cars from the show Street Outlaws, which is Discovery Channel, showed up. We do it for a charity this year. We did it for Devereaux Behavioral Health, which is a nationwide organization. They asked us to collect art supplies, part of their therapy process for these young folks who are going through difficult times is the use of art in that therapy. And it's really cool. We got to go tour the facility. Anyways, we gathered, it was like 3,500 pounds or something ridiculous of art supplies, and an additional couple $1,000s that we were able to donate, and really fun morning. So yeah, that's if you do follow us on those, you'll see when that comes up. And frankly, it's a cool enough car show that it's even worth, if you're not from Arizona, it's worth coming out for, because it's a really fun event. And I serve my homemade, best in the world orange juice. So.
Nice. Awesome. Well, thanks, Mick. Much appreciated. Good legal insight here. I'll know how when Tim tries to press charges for me not paying him, I'll know you represent me. I had dibs. Tim, you find your own lawyer.
Whatever, Carl, I'm going to Zoom you. I've got a list of all the verbal slights, and each one worth at least $1,000 of pain and suffering.
Guys, dibs is a legal concept. So that's
established dibs.
I remember calling dibs on young ladies back in the day and believing it was also enforceable. It's not, and they don't like it. So
awesome. Okay. All right. Well, thanks, Mick, Matt, Tim. We'll be back again soon. I think we're going to have another physics podcast in the not too distant future. But thanks, Mick, and we will talk to you later.
See you.